And inspected means you gave a document, they inspected it, whether it's the visa, a Canadian passport, a British passport, they're coming on an I-94 waiver, whatever it is, you gave some sort of document that that now you are inspected, and when you're inspected, they stamp something and let you in. Now, if you got married to an American citizen, what the law says is up to a week ago, you need to be admitted and inspected. In addition to that, there's a separate law that said that you could also get your green card here through marriage to a citizen if you qualify under 245I, which means that you were physically present here on December 21st, 2000, and you had something filed in the system before April 30th, 2001. And that's been basically the rules for the last decade. And last week,
So when they say,
hear me out.
when they say no, you got to show hardship.
Hear me. I'm going to get to it all. I'm going to get to it all, I promise, okay? But I want everybody to understand, so we don't have to take the same call, because we're going to get that same call every day. So I'm going to try to explain it so everybody understands, okay? So now that's been the law we've been working on for the last 10 years. Now the Board of Immigration Appeals came down with a decision, and their decision says is you did not have to be inspected. You only had to be admitted. Admitted means you came through the airport. Admitted means you came through the border crossing. Now, it depends on how you came. For example, the woman who appealed the decision to deport her, who said she was admitted and eligible to adjust her status, she was in the back seat of a car. And it was agreed upon that she was in the back seat of a car, and they talked to the woman in the front seat, and they never said anything to the woman in the back seat. And the officer waved her through. She was admitted. She didn't give any document to be inspected, but she was admitted. Now, take a different scenario. A different scenario, which happens quite often, is somebody comes on somebody else's documents, and they didn't come here on their name. They came here as somebody else. Now those laws are a little different in the sense that you were admitted and inspected, albeit as somebody else. So this BIA change doesn't affect the people who came here as somebody else. This BIA change affects people who got driven across the border and no questions asked. That's basically how this law affects people. And those people are now eligible to adjust. Now, for the people who came here as somebody else, depending in which jurisdiction you live in, the courts have interpreted the laws differently. So, for example, the Second Circuit Court of Appeals says that you were admitted and inspected even as somebody else. So you would be eligible to adjust your status here because you were admitted and inspected. And then you show the document, I was admitted and inspected. Here's the document I came as. My name is Mark, but I came as Joe. But now they're going to deny you because they say you lied to us. You committed a fraud. And then you need to file a waiver based on hardship, which is what you were just talking about. Now, you can do that in New York and Connecticut. In New Jersey, which is the Third Circuit, which takes a different view, and their view is that you were not admitted and inspected. Somebody else was admitted and inspected. Okay? You were not admitted, and therefore, you cannot adjust your status. So in New Jersey, the law says you can't do it. In New York, the law says you can do it. So if you live in New York, you can do it, except you got to be willing to accept the consequences if your hardship waiver is not approved, which is that you would get denied and put in deportation. And hardship waivers are very hard to prove. The law that changed last week, to reiterate, the law that changed last week is the law that for basically the fact pattern of the person who gets driven across the border, no questions asked. Previously, that person was considered entered without inspection. Now that person is considered admitted and can adjust as long as they can prove that those facts actually happened.
So for those people who come on somebody else's paper, they have to wait until the law change?
No, I just told you. If you live in New York, you live in Connecticut, you can adjust if you have the document, but you have to file a hardship waiver. And the hardship waiver is very difficult to get, so you have to be willing to take the consequences of getting denied and being put in deportation. But yes, you are eligible to adjust. What I would suggest you do is you give us a call at 1-800-522-0804 if you want to discuss your specific case in greater detail. Make an appointment to come see me. I do charge a $120 consultation fee, and we'll be happy to help you.